Welcome to the Deep Dive. This is where we take complex topics, grab some expert sources, and really try to unpack them into useful insights.
That's the plan.
And today, we're diving into something fundamental in English conflict of laws. But wow, can it be tricky? We're talking personal connecting factors.
Specifically, domicile and residence.
Exactly. Did you know, for instance, you could live somewhere for, say, 30, 40 years?
A lifetime almost.
Right. And the law might still say, nope, that's not your legal home.
It happens. Or that if you leave the place you chose to live,
Yeah.
your childhood domicile, maybe halfway across the world, could just, well, legally pop back up.
It sounds quite strange, doesn't it? But it's vital stuff. So that's what we're unpacking today, the sometimes weird world of domicile and residence.
It's a fascinating area.
Before we jump in, though, first things first, a huge thank you to the University of London
Absolutely.
for making these excellent documents available for educational purposes. It's incredibly helpful.
It really is. Great material.
And just to be clear, this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
Mm-hmm.
And it's purely for educational use. So for everyone out there hitting the books on this topic, maybe for exams,
Good luck.
you've absolutely got this. Seriously, good luck.
Domicile and residence, they really are crucial. You know, in conflict of laws, they're often the very first thing you look at,
The starting point.
pretty much.
Mhm.
For figuring out which country's law applies to some really big life events, we're talking things like whether your marriage is valid or your divorce.
Okay, important stuff.
Hugely important. And who inherits your property, that's wills and succession, your capacity to make contracts, even some aspects of tax. Getting these connecting factors right is, well, foundational.
Right. So here's our mission then. We're going to unpack domicile looking at the different types: origin, choice, dependency.
The three main flavors.
And the really tricky bit, how do courts actually figure it out? Looking at someone's life, their intentions.
Which is often where the arguments happen.
I bet. And we'll see how the rules apply to different people. Then we'll look at habitual residence.
Another key term. Increasingly so.
And crucially, highlight the differences. How does domicile stack up against habitual residence? We use this great University of London material as our guide.
Sounds like a plan.
And the focus is on understanding the principles and applying them, like you might need to do in an exam situation.
And you really can't get a feel for this without looking at the cases. These rules weren't just dreamt up.
No.
They were hammered out by judges dealing with real people, complex lives, over centuries. The case law is where you see how the principles actually work, or sometimes how they cause problems.
Right, let's get into it then, starting with that big one, domicile itself. Why does the source material say it has this dominating role? What makes it so central?
Well, partly history. English common law traditionally relied heavily on domicile. It was the main personal connecting factor for a long time.
More than, say, nationality?
Historically, yes, for many core areas. While nationality and residence are used now, domicile still holds sway, especially, as the source points out, in family law, divorce, matrimonial property.
Okay.
And also for things like personal capacity, can you legally make a contract?
Yeah.
A will. And yes, some tax issues too.
Right.
And here's a really fundamental point the source makes, absolutely vital to grasp. In English law, there's only one concept of domicile.
Only one, not like a tax domicile and a family law domicile.
Well, legally, no. People might talk like that informally, but the rules an English court uses to decide if you're domiciled here for, say, inheritance tax
Yeah.
are exactly the same rules they use to decide if you're domiciled here for marriage capacity or divorce jurisdiction. It's universal.
Okay, that's important. One set of rules.
One set. The source mentions cases like Wendance v. AG, Ramsey v. Liverpool Royal Infirmary, IRC v. Bullock, Reefers, classic examples.
And these cases illustrate.
They show the single concept being applied across different legal questions, tax, charity bequests, whatever. And interestingly, in several of those, the court found an English domicile hadn't been acquired despite the person living here for ages.
Decades sometimes, right?
Exactly, which underlines the point that just living somewhere, even for a very long time, isn't automatically enough.
Which brings us to the definition problem. You'd think permanent home would cover it. The source mentions that old definition from Wicker v. Hume.
It does sound simple.
But then, bam, reality check. Cases where people live somewhere 30, 40, 50 years, and court says, still not domiciled here. So permanent home can't be the whole story.
Absolutely not. And that's why the source, in cases like Bell v. Kennedy, stress that domicile isn't just a place. It's an idea of law.
An idea of law.
Okay.
A legal construct.
Exactly. A legal connection that might not match your everyday feeling of home.
So how does it diverge from just home? The source lists a few ways.
It does. First, domicile connects you to the law of a country or even a specific legal system within a country.
Like England versus Scotland. Or California versus Texas.
Precisely. Different legal systems. The source gives the example of someone emigrating to the U.S. They intend to settle, but haven't decided where Florida, Oregon.
Still thinking about it.
Right. Until they choose and settle within a specific state's legal system, they haven't acquired a U.S. domicile of choice. They keep their old one. You need that connection to a particular system of law.
Okay, makes sense. You need to land in a specific jurisdiction. What else?
Second, changing borders. What happens if your country disappears, like the Soviet Union, Yugoslavia?
Oh, yeah. Good question.
The source notes the law hasn't fully worked this out, but the general idea is your domicile follows the territory. If you're Yugoslav living in Dubrovnik,
Which became Croatia.
you'd likely become domiciled in Croatia. Your legal connection shifts with the governing legal system of where you are.
Right. And the third divergence.
This links back to those long-term residents. Acquiring a domicile of choice isn't just about having a permanent home. It needs that specific intention.
The intention again.
The intention to reside there permanently or at least indefinitely. You could live somewhere for decades, consider it home, but if you always secretly plan to leave on retirement...
Or when a job finished.
Exactly. That underlying definite plan to leave might mean you never acquired the necessary intention for domicile of choice there.
Ah, okay. Presence plus that very specific open-ended intention. Got it.
And the source adds a couple more differences too, right?
It does. First, everyone has a domicile. The law insists on it.
Even if you don't have a physical home.
Even a vagrant?
Yeah.
Legally, they must have a domicile somewhere. The law needs that anchor point.
A legal peg to hang things on.
You could put it like that. And second, some people can't choose their own domicile. Children under 16 are the main example now.
Their domicile depends on someone else?
Yes. Their legal domicile might be France because their parent is domiciled there, even if the child has never left England. Their factual home doesn't change the legal dependency.
That difference between fact and law is stark there. Okay, let's nail down the core principles then. The absolute must-know rules. Right. These are fundamental, set out in FVF first. No person can be without a domicile.
Never.
Never. From birth, you get one, your domicile of origin, and you always have one. No gaps allowed. Mark v. Mark confirmed this.
Okay, principle 1. Always got one.
Principle 2. No person can have more than one domicile at the same time for the same purposes.
Only one hat fits.
Exactly. Think of the mess otherwise. IRC v. Bullock stressed this. Which law applies if you have two domiciles? Chaos. So one domicile for things like marriage, succession, etc.
All right, principle 2. Only one at a time.
And third, and this is crucial for proving things, an existing domicile is presumed to continue until it's proven that a new one has been acquired.
Innocent until proven domiciled elsewhere.
Sort of. The burden of proof is on the person claiming a change happened. That goes back to cases like Winans v. AG.
And the standard of proof. Is it really tough?
Not criminal standard, thankfully. It's the civil standard. Balance of probabilities.
So more likely than not.
Exactly. You have to convince the court it's more probable than not that the person changed their domicile. Still needs solid evidence, especially for intention, but not beyond reasonable doubt.
Okay, let's recap those 3 again. Always have one. Only one at a time. Existing one continues unless a change is proved on the balance of probabilities.
Perfect. And there's one more vital rule the source highlights, which can feel a bit odd.
Go on.
When an English court is deciding where someone is domiciled for its own legal rules,
Yeah?
it applies English rules of domicile to figure that out. It doesn't matter what, say, France thinks that person's domicile is according to French law.
Really? So England uses its own definition?
Yes. Ansley is the classic case. Englishwoman lived in France for 50 years, intended to stay forever, by English rules, domiciled in France.
Okay.
But French law had some formality she hadn't done, so France said she was still domiciled in England. The English court said, nope, we use our rules. By our rules, she's French domiciled.
Wow. So the English court decided French law applied, even though France disagreed she was French domiciled.
Precisely. Lawrence v. Lawrence is another example. It shows the English court applies its own legal framework to classify domicile for its own purposes.
That's a mind bender. Okay, principles locked down.
Right.
Now, how do you actually get a domicile? The source mentions 2 main ways, origin and choice.
Exactly. Everyone starts with a domicile of origin. You get it at birth. It's not where you were born, but based on your parents.
How does that work?
If you're legitimate, it's your father's domicile at your birth. If illegitimate or your father died before you were born, it's your mother's domicile.
And foundlings.
Theirs is the country where they are found. Simple but necessary rule.
And the source says this domicile of origin is really sticky. Hard to change.
Very sticky. You can only really change it later through adoption, and it has this quality of tenacity.
Tenacity, meaning.
It's harder to shake off than a domicile you choose later, even if you leave your country of origin absolutely determined never to go back.
Burn your passport, the whole deal.
Metaphorically, yes, but
Yeah.
still keep that domicile of origin legally until you successfully acquire a new domicile of choice somewhere else.
So it clings on. No gap year for domicile.
No gap year. It clings on. That's very different from losing a domicile of choice.
How so? What happens if you leave your chosen domicile?
Right. If you've acquired a domicile of choice, say you moved to Canada and intended to live there forever, and then you leave Canada, intending never to return.
Okay.
You lose that Canadian domicile of choice instantly. The moment you leave with that intention, it's gone,
Poof.
pretty much. And then comes the really unique bit. Unless you immediately acquire a new domicile of choice somewhere else,
Which might not happen straight away.
often doesn't. In that gap, your domicile of origin automatically revives. It springs back into legal effect by operation of law.
Wow. Okay, let me try that back. Origin. Get it at birth. Super sticky. Hard to lose. Just waits. Choice. You acquire it through intention and residence. Lose it the second you leave intending not to return. And if you don't immediately get a new choice domicile, your origin one pops back up.
You've got it. That automatic revival of the domicile of origin is a defining feature of the English system. Easy to forget in a problem question.
I'll try to remember. Origin is tenacious. It revives. Choice is lost on leaving. Then origin might pop back.
Exactly. Now let's dive into getting that domicile of choice. Any independent person can get one.
Independent meaning.
Not a child under 16 or someone lacking capacity.
Okay. And what do they need?
Two things together. Residence in the new country and the intention to live there permanently or indefinitely. Repeat that. Residence plus intention.
Residence plus intention.
Well,
Okay, let's break down residence. Just being there.
being there as an inhabitant, that's the phrase from IRC v. Duchess of Portland. Living there, not just passing through as a tourist.
Does it have to be for a long time?
Not necessarily. The source stresses this. It can be incredibly short if the intention is crystal clear. White v. Tennant, that American case, is the classic illustration.
What happened there?
Guy leaves his old home state, crosses into the new one, puts his stuff in a house, fully intends to live there permanently, gets sick that same day, dies a day later without even spending a proper night there.
Yeah.
Court said that brief physical presence, combined with the clear intention, was enough. Domicile of choice acquired in less than a day.
Incredible. So an immigrant could get it on day one if they arrive with that settled intention.
Theoretically, yes. The intention carries huge weight.
What about illegal residents? Can you acquire domicile if you're somewhere illegally?
Tricky one. The English case Putic v. AG involved a member of a German terrorist group living illegally in the UK. The court said no, you cannot acquire a UK domicile of choice based on illegal residence here.
Okay, that makes sense for the UK.
But the source raises a neat point. What if the illegal residence was elsewhere? Say, someone illegally resident in Germany, but the case comes before an English court. Would the English court say illegal residence anywhere prevents domicile? Or just illegal residence here prevents it?
An open question.
Seems to be. A subtle point about how far the Putic rule extends.
Okay, so residence needs presence as inhabitant, maybe lawful, at least here. Duration isn't key if intention is there. Now that intention, permanently or indefinitely, what does that really mean?
It means a settled purpose to make that country your home without any definite time limit or specific end goal in mind. Not just for a 5-year contract, even if you like it there.
No fixed departure date planned.
Exactly.
Yeah.
What about what-ifs, contingencies?
Yeah, like I'll stay unless I win the lottery.
The source says vague, unrealistic stuff like that is ignored. The law treats you as intending to stay permanently.
Okay.
But if the possibility of leaving is concrete and reasonably anticipated, like, I'll leave when this specific job ends in 3 years, or when I retire at 65 and move to Spain, that kind of foreseeable event might prevent you having the necessary indefinite intention now.
So vague dreams don't count. But concrete plans might stop you getting domicile now.
That's the general idea. It's about whether there's a definite contingency you're planning around.
What about becoming a citizen, getting naturalized? Does that automatically mean you have the intention?
It's strong evidence, definitely. Shows commitment. But the source is clear. It's not decisive on its own. Just one piece of the puzzle the court looks at.
Right, which brings us to the big challenge. How does a court figure out this intention, especially years later, maybe after someone's died? It sounds like mind reading.
It's the toughest part. No mind reading, obviously. They infer it from conduct, from circumstances. The quote from Dreven v. Dreven is key. No act, no circumstance, however trivial, ought to be left out of consideration.
Everything.
Everything. Your job, where you bought property, where your family is, your finances, your health, your religion, your social life, letters you wrote, things you said. The source quotes Cheshire, North, and Fawcett mentioning aspirations, whims, amours, prejudices.
Wow, they really build a whole picture of your life.
They have to. It's like detective work. Now, the person themselves can testify about their intention.
But the court might be suspicious, since they have an interest.
Naturally. What you said out of court at the time can also be evidence declarations to friends, family, in documents. But again, cautiously.
How do they weigh those declarations?
Ross v. Ross gives the test. Consider who you said it to, why you said it, when you said it. Was it casual chat or a formal statement? Trying to impress someone.
Context matters.
Hugely. And the absolute killer point for declarations, they need to be backed up by your actions.
Actions speak louder than words.
Absolutely. Declarations must be fortified and carried into effect by conduct and action consistent with the declared expressions. If you say you intend to live in France forever, but all your actions point to keeping England as your real base.
The court will believe the actions.
Almost certainly. Conduct is king when it comes to proving intention for domicile.
Okay. And one more thing about residence. Something about being freely chosen.
Yes. From Udny v. Udny, the residence shouldn't be dictated by external necessity, like being posted somewhere for military duty or fleeing creditors, or maybe being somewhere purely for health reasons. That lack of free choice might weaken the argument for acquiring domicile there.
Got it. Okay, let's try a quick sum up of this core bit. Domicile, key legal connector. Different from home. Rules. Always one. Only one. Existing continues.
Oh.
2 types. Origin, birth, tenacious, revives, and choice. Needs residence plus intention. Residence as inhabited, maybe lawful, duration less key. Intention, permanent, definite, no fixed end, judged on all conduct. Actions, words. Residence ideally, freely chosen.
Excellent summary. Those are the absolute fundamentals.
Now, how do these rules play out for specific groups? The source mentions prisoners, refugees, people working abroad.
Right, let's look at those categories. Prisoners. Their residence is obviously not chosen. So generally, they keep the domicile they had before going to prison. But they can acquire a domicile of choice in the prison country if they form the intention to settle there after release.
It's about the future plan.
Exactly. Not the current involuntary residence. Now, persons liable to deportation. Their residence is precarious, shaky, hard to form that permanent intention.
Makes sense.
But if they do manage to form that intention, they can acquire domicile. And Crew v. Crew adds a specific point. Getting a deportation order doesn't automatically mean you lose domicile you already acquired.
Only if you're actually removed.
Only upon actual deportation. The order itself isn't enough.
Okay, what about refugees and fugitives? People fleeing danger or justice?
Complex. For political refugees, if they genuinely intend to go back home when things change, they usually keep their old domicile.
But the intention has to be real, not just wishful thinking.
Exactly. If the prospect of return is basically zero, just an exile's longing, the court might say they've abandoned that intention and can acquire domicile where they fled. Lloyd Evans versus May v. May showed different outcomes based on that assessment.
Okay. And fugitives from justice?
The starting assumption is they don't intend to return, so they abandon their old domicile, Martin. But look at Moynihan v. Moynihan.
The guy who fled fraud charges?
Yes. Fled the UK, but then lived in the Philippines for 20 years. Built a business, family, property, a whole life.
Despite being a fugitive?
Yes. The court said his conduct over those 20 years showed clear intention to settle permanently in the Philippines, overriding the initial reason for being there. He got domicile of choice there.
Incredible. Conduct trumping the reason for leaving.
Powerful example. Now, invalids. Moving for health reasons.
Right.
Is it freely chosen? Is the intention permanent?
Tricky line.
It is. Just going for temporary treatment. Probably no domicile change, but settling somewhere permanently for its health benefits. That could show indefinite intention. Hoskins v. Matthews touched on this. Depends on the facts.
Okay. Armed forces.
Members of the armed forces. Historically hard, now clear they can get domicile of choice if they form the intention. Donaldson v. Donaldson. But realistically, constant postings make it rare.
And people moving for work. Employees.
Going just for a job, intending to leave when it ends. No domicile of choice. A.G. Rowe, the Chief Justice of Ceylon, planning to leave at pension classic case. Retain English domicile.
But if you move for work and decide to settle for good,
Then yes, you can acquire domicile of choice. It's about whether the intention goes beyond just the job itself.
and diplomats, similar story.
Pretty much. Usually tied to a temporary posting, so presumed not to acquire domicile. But again, not impossible. If they form the independent intention to settle permanently, they can. Naval v. Naval is an example.
So for all these groups, it's still residence plus intention, but their specific circumstances heavily influence how a court views those elements, especially the freely chosen aspect and the terminant definite intention.
Precisely. You apply the same core tests, but the context is crucial in assessing the evidence.
Right. Let's quickly cover losing domicile.
Okay. Domicile of origin, you never truly lose it, right? It just waits or revives.
Got it. So how do you lose a domicile of choice?
Two things needed again. You have to physically leave the country.
Cease residence.
And you have to stop intending to live there permanently or indefinitely.
Cease intention. Both required.
Both. Just leaving for a holiday doesn't cut it if you still intend it as your permanent home. You need the departure and the loss of that specific intention.
And if you lose a domicile of choice, what happens then?
Two possibilities. Either you acquire a new domicile of choice straight away in the next place, or if you don't, that trusty domicile of origin revives instantly by operation of law, fills the gap.
Always waiting in the wings.
Yeah.
Okay, dependency next. People whose domicile follows someone else's.
Yes, domicile of dependency. They can't acquire their own domicile of choice. Their domicile is legally tied to someone else's and changes when that person's changes.
Historically, the source says this included married women, children, and those with mental disorders.
That's right. But for married women, things changed dramatically on 1st January 1974.
The 1973 Act.
Exactly. Before that date, a wife's domicile automatically followed her husband's. Didn't matter if they lived apart for decades, like in Rescullard. Lord Denning called it the last barbarous relic of a wife's servitude in Gravy Formosa.
Strong word. So what changed?
Since 1974, Section 1 of the Act says a married woman's domicile is figured out just like anyone else's. She's independent, can get her own domicile of choice based on her own residence and intention.
Simple enough for marriages after that date.
Mm-hmm.
But what about women married before 1974? The source mentions a transitional rule, Section 1-2.
Yes, the slightly tricky bit. If a woman was married before 1974 and on that date, her domicile was dependent on her husband's.
Yeah?
Section 1-2 treats her as keeping that domicile, but now it's considered as if it were her domicile of choice, a quasi-choice domicile.
So it converts her dependent domicile into a choice one.
Sort of. She keeps it until she actively changes it, either by acquiring a new domicile of choice somewhere else or by reviving her domicile of origin.
Can we use the examples, Mrs. A and Mrs. B?
Good idea. Mrs. A, married before 74, settled in New York with hubby by 1970. On 11/74, she's living there with intent. The Act basically says, okay, you now have a NY domicile of choice by operation of the Act.
Right, and Mrs. B.
Mrs. B, also married before 74, always wanted to live in NY, but on 11/74, she's still living with her husband, who's domiciled in England. The Act makes her independent, but S12 says she retains his English domicile as if it's her domicile of choice.
So she doesn't automatically get her desired NY domicile.
No. To get that after 11/74, she still has to move to NY, live there as an inhabitant, and form the necessary permanent intention herself. The Act gave her the capacity, but didn't magically move her domicile for her.
It seems a bit convoluted. Why not just make everyone independent fully from day one?
It did create complexities, definitely. Cases like IRC v. Duchess of Portland wrestled with interpreting it, and academics like Wade debated it. It was a transition mechanism key date, 11/1974.
Wow. Now, children under 16, as the source calls this, quite complicated.
It can be. The basic common law rules depend on legitimacy and parents. Legitimate child follows father's domicile. Illegitimate, or father dead, follows mother's domicile. Legitimated child follows father from legitimation. Origin was mother's. Adopted. Treated as a legitimate child of adopters. No living parents. Domicile probably can't be changed.
And there's that weird rule from Ree Beaumont about mothers changing domiciles.
Yes, the anomaly. A father changing domicile automatically changes the child's, but a mother changing hers only changes the child's if it's shown to be in the child's interest. A constraint on mothers not applied to fathers.
But didn't the 1973 Act change things for children too, especially if parents separate?
It did. Section 4 is really important here. It applies when parents are living apart or were when the mother died. It overrides the common law.
Okay, what does Section 4 say?
If the child lives only with the mother, domiciles the mother's, changes with hers.
Simple enough.
If that rule applied before and they haven't since lived with the father, same thing, domicile follows mother. And if the mother dies while the child's domicile follows hers under these rules and the child hasn't since lived with the father, the child keeps the mother's last domicile before she died.
Wow. So you absolutely have to check Section 4 if parents are apart. It's not just the old father-mother rules.
Definitely. You check S.4 first in those situations. Finally, dependency. Those suffering from a mental disorder,
The rule here.
if they lack capacity to form the intention, they can't get a domicile of choice. They just keep the domicile they had when the incapacity started.
And an exception.
If the incapacity started when they were still a dependent child, their domicile continues to follow the dependency rules, as if they were still a child, for as long as the disorder lasts.
Okay, so summing up dependency today, only children under 16 and those lacking mental capacity. Married women became independent in 74, but watch out for those transitional rules for pre-74 marriages.
That's the current picture.
Right, let's shift gear slightly. We've done domicile to death. What about residence, especially habitual residence?
Yes, hugely important now, especially because it's used in lots of international conventions, like the Hague Conventions, that the UK follows.
And the source says the conventions don't actually define it.
Correct. Riem confirms that. It's left to courts to figure out based on the facts. And crucially, it's seen mainly as a question of fact, not a technical legal concept like domicile.
So what makes residence habitual? Just living there a long time.
Not just length. Cruz v. Chittum calls it a quality of residence, a regular physical presence which must endure for some time. Habitual implies a pattern, stability.
More than just visiting.
Definitely. And unlike domicile of choice, you can't get it instantly. Rijay says it needs an appreciable period of time and a settled intention.
Hold on, settled intention. Didn't we just talk about intention for domicile? Is it the same thing? A VA mentioned intent for long-term residence.
Good spot. There's definitely overlap in the language, which can be confusing, but the general view is that the settled intention for habitual residence, HR, is a lower bar than the permanent or indefinite intention for domicile.
Less strict.
Generally, yes, a settled purpose for being somewhere, even if not forever, might be enough for HR. Think of it as easier to acquire and also easier to lose than domicile of choice.
Okay, and you can keep your HR even if you're away temporarily, like on holiday.
Yes, temporary absence doesn't break it. Onjian v. Onjian. You lose HR when you leave a country with a settled intention not to return there.
Right. So what are the absolute killer differences between domicile and HR? The source lists them out.
Let's run through them. 1. Nature. Domicile, legal concept. HR, equals factual concept.
Okay.
2. Existence. Everyone must have a domicile. You can have no HR, e.g. a nomad.
Big difference.
3. Number. Only one domicile. You can have more than one HR simultaneously. You could be splitting life between two countries.
Multiple HRs. Wow.
4. Origin revival. Domicile has tenacious origin and revival. HR has nothing like that.
No safety net for HR.
Intention. Domicile needs permanent, indefinite intention. HR needs settled intention over an appreciable period, generally less demanding.
Lower bar.
6. Dependency. Domicile has strict dependency rules. Kids in capacity. HR is usually based on individual facts, though parental intention is key for a child's HR. It's not the same rigid legal dependency.
That's a really clear contrast. So, wait, you could genuinely have no habitual residence.
Yeah, someone constantly moving, never putting down roots with that settled intention for an appreciable period anywhere. They might lack HR, but they'd still have their domicile, likely origin.
And definitely possible to have HR in, say, London and Paris, if you genuinely live a stable life in both.
If the facts support it, yes, regular, stable presence in both. But you'd still only have one domicile. That highlights HR's flexibility, but also maybe its potential instability as a single legal anchor compared to domicile.
Gotcha. The source mentions HR comes up a lot in child abduction cases, but says that's a separate topic.
Exactly. The Hague Child Abduction Convention uses HR heavily, but the rules and cases there are very specific and beyond our scope today.
Okay, application time. Let's put this all together. The source has some warm-up questions first. Is domicile Victorian? Needs reform? Better to use HR or nationality?
Yeah, those are great for critical thinking. Does domicile, with its sticky origin and revival rule, really fit modern life? You can see the arguments. Comparing it to HR factual, flexible but potentially none or multiple, and nationality, stable but useless if you emigrate, really makes you weigh the pros and cons.
Good exam-style thinking points, but the real test is the problem question. Sam's life story, the source advice. Clear head, logical steps, analyze every fact.
Absolutely. Let's walk through Sam's life chronologically, applying the rules. Ready?
Let's do it.
Sam, born Greece, 1942. Legitimate. Father Ben, domiciled Greece. Rule. Origin, fathers at birth. Sam's domicile of origin. Greece stays with him.
Okay, Greek origin.
Ruth remarries Josh. Ben presumed dead. Sam, under 16, dependent. Rule. Follows mother if father dead. Where's Ruth domiciled? She's fleeing, residence not chosen. Unlikely she acquired new domicile, so she likely retains her old one, maybe Greek origin revived. Sam follows Ruth, stays Greek origin.
So Greece.
1944, Auschwitz deportation. Rule. Involuntary residence, no change. Sam retains Greek origin.
So Greece.
1946, Palestine arrival. Smuggled in. Precarious. Ruth drowns. Sam, under 16. Did Ruth get Palestine domicile? Very unlikely. Rule. Child keeps previous domicile. Sam likely retains Greek origin.
Still Greece. Seems very tenacious.
Meanwhile, Ben's alive. In France, prospering lawyer. Inference settled life. Rule. Could acquire French domicile of choice if intended permanent residence. Plausible. Assume he did. Ben, French choice.
Okay, Ben's French now.
1954. Ben to Cairo. Fact, intends to take till pension. Rule, limited purpose, AG Euro, unlikely domicile change. Fact, began to think future lay there, hints at change, but weak. Ben likely retains French choice.
No French.
1957. Forced leave Egypt. Doesn't matter if he had Egyptian domicile. Unlikely. He loses it on leaving. Retains French.
Back to France.
1958. Ben, back in France, can't settle. Leaves for Israel to see if he likes living there. Rule, leaves France intending not to return. Loses French choice. Rule, going somewhere to test the waters. Not permanent intention yet. Rule, domicile of origin revives. Ben's Greek origin revives.
Back to Greek origins for Ben.
Wow, 1958-59. Ben and Sam reunited in Israel. Ben still testing waters. Unlikely Israeli domicile yet. Sam, under 16, living with Ben. Rule, dependent follows father. Sam's domicile follows Ben's. Greek origin.
Sam's Greek again.
1959, moved to Australia. Ben's firm sets up office. He moves with it. Inference, strong sign of permanent move. Rule, residence plus intention choice. Ben likely acquires Australian domicile of choice. Sam is under 21. Pre-74 Act, dependency might last till 21. Assume Sam's still dependent. Rule, follows father. Sam's domicile becomes Australian choice.
Sam's Australian. Finally changed.
1960-63,
Yeah.
Sam at Uni Sydney, living with Ben. Still under 21, still dependent. Sam's domicile, Australia choice.
Still Aussie.
1963, Sam to Harvard, USA. Sam turns 21. Rule, becomes independent. His domicile is his own now. Fact, scholarship, limited purpose. Fact, dislikes U.S. climate, no intention. Sam does not get U.S. choice. His domicile remains his last one, Australia choice.
Stays Australian despite being in U.S.
1966, job in Minnesota. Fact, still dislikes U.S. Fact. Job hunting back in Australia. Rule, clearly no permanent indefinite intention. Sam does not get U.S. choice, remains Australia choice.
Still Australian.
1967, Sam returns to Israel. Fact, war starts. Maybe temporary reason. But stays 10 years, marries, job integrated. Rule, strong conduct over long periods shows intention, actions, initial reason. Sam acquires Israeli domicile of choice.
He's now Israeli domicile.
Big change.
1977. To Cape Town, South Africa. Fact. Uni job, maybe limited. Fact. Could not settle. Political critic. Arrested in prison. Rule. Suggests lack of intention to make SA home. Residence maybe not freely chosen due to politics. Prison involuntary. Retains domicile from before prison. Sam likely retained Israeli choice.
Still Israeli through the SA years. 1992. Released. Comes to England. Fact. Teacher job. Fact. Gets UK citizenship. Relevant. Intention. Fact. Always talked of returning to Israel if true peace. Rule. Is this contingency vague or anticipated prevents? True peace sounds pretty vague. Conduct, job, citizenship, long residence seems strong. Strong argument, Sam acquired English domicile of choice. Alternative, if contingency did prevent it, Greek origin might revive if he lost Israeli choice leaving for SA. English choice seems more likely.
Okay, likely English domicile now.
2002. Here's about Dad in Sydney. Talk of bringing Dad to England suggests England is his base. Consistent.
From England.
Last week, Sam sets out for Australia. Dies en route. Rule, needs residence plus intention in the new country. Died before arriving. Domicile at death, the one he had before leaving England.
So where was he domiciled at death?
Based on the analysis, most likely domicile of choice in England. The conduct points strongly there, outweighing the vague contingency. The alternative, less likely, is Greek origin revived. You'd discuss both in an answer.
That is incredibly detailed. tracing every step, applying the rule, noting the changes, the dependencies, the losses, the revivals.
That's exactly the process. Analyze every fact, apply the relevant rule at that point in time.
Shows how vital it is to know those rules inside out and track the timeline. Wow.
Absolutely. It's methodical.
Okay, let's reflect quickly. The source learning outcomes. Define domicile. Use principles. Explain dependency. Distinguish from HR.
Hopefully working through this, especially Sam's story, has helped solidify those points.
I think it has. Seeing it applied makes a huge difference.
So key takeaways. Domicile. Crucial legal concept, not just home. 3 types. Origin, sticky, revives. Choice, needs residence plus proven intention. Dependency, kids, incapacity. Habitual residence, more factual, flexible, increasingly used key differences, can have non-multiple, no revival. Cases and assessing intention are vital.
Which leads to that final thought. Given all this complexity, the intention tests, the revival of origin, the dependency rules, and comparing it to maybe more factual tests like habitual residence, is domicile really fit for purpose today in our supermobile world?
It's a very valid question. Does it need reform? Would HR or nationality be better overall? There's no easy answer, but it's the kind of critical thinking these concepts demand. Definitely something to mull over.
Food for thought indeed.
And just keep practicing. Applying the rules to different scenarios is the best way to master this.
Absolutely. Once again, huge thanks to the University of London for the materials. This deep dive, brought to you by Sinorbit Academy, Sri Lanka, was strictly for educational purposes. Thank you so much for joining us on the deep dive. And seriously, to everyone facing exams on this, the very best of luck.
Yes, very best of luck. Keep working through it. You'll get there.